Judge stops the entire courtroom after the defendant tries to argue his bond with a story nobody expected.
There we go.
Your name, sir?
Nicholas Chafee.
All right. Court has before it a plea form that indicates that the defendant is going to be pleading the charge of aggravated domestic violence to 1-year offense. On his successful plea to that charge, counts 1 and 2 would be dismissed. There's also agreement between the parties to no upfront jail, recognizing that this court cannot bind the sentencing judge in this matter.
I've explained that all to my client.
All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Nicholas Chafee.
All right, sir, it is this court's understanding that you're going to plead no contest to the charge of aggravated domestic violence.
Yes, Your
That
Honor.
is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. Do you understand that?
I do, Your Honor.
All right. Do you understand what a no contest plea is?
I do, Your Honor.
All right. 2 things about a no contest plea I have to make sure that you understand. The first thing is that you have to understand that it means that you're not further desirous or wanting to contest this charge. You understand that?
I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
I do, Your Honor.
And you understand, sir, that also while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Perry, 15th District Court.
I understand that, Your Honor.
All right. Basis for the no contest plea.
Intoxication, Your Honor.
All right. So, sir, to that charge, how do you plead?
No contest, Your Honor.
All right. Now you understand that by pleading no contest, you will not have a trial of any kind.
I do.
You signed an advice of rights form, is that correct?
I did, Your Honor.
Any question regarding any of those rights?
No questions.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
I do.
Are you on probation or parole?
I am not, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
I am.
and of your own free will?
I am.
All right. The court has been provided and has reviewed Andover Police Department report for their case number 25-13270. Any objections to the court having reviewed that report?
None, Your Honor. No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine a defendant's guilt to this defense counsel. Have I complied with the court rule?
Yes, Your Honor. People are satisfied.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
May 28th at 9 a.m. for Judge Perry.
May 28, 2025, at 9 a.m.
Yes, sir.
9 a.m. before Judge Perry.
Your Honor, may counsel approach real quickly?
In today's hearing, everything changes when the judge reminds the defendant that his past violations weren't just small mistakes, they were done, as the judge puts it, in spectacular fashion.
Court calls the case, People versus Stephen Smith.
APA Rachel McDonough for the people on all 4 cases.
James Fifelski appearing on behalf of Mr. Smith on case ending with 5506. This is the one that we have another attorney on this. I'm not sure where she is.
Who's on it?
Okay, thanks. They're going to try to find her right now.
Perry. You can actually do it, Mike, because they're going to have to be adjourned.
Mike Getty, Assistant Public Defender on behalf of the defendant, Your Honor. Mr.
The
Smith.
court received information that this gentleman was in Monroe County. The writ was done to get him here from there. However, in the interim, he was transferred, I think, to Jackson County. So he was not picked up and won't be here.
Okay.
All
A
right.
lot of construction, Judge.
All right. So was this originally mine?
Yes.
Okay, so my next date is That we won't have enough time. All right. So preliminary examination, court will find good cause. I'll adjourn it in person to June 3rd, 2025, 9 a.m. That's before me.
Thank you, Your Honor.
Your
And
witness.
his bond will continue.
Thank you very much, Your Honor.
All right, thank you.
What time did you say? What time did you say? 12 o'clock?
Really? What time do I always say?
12 noon. That's what it was today.
God sakes, Snifowski.
9 o'clock. That's the
Yes, it's
second.
9 o'clock.
Okay,
I'll put
okay.
you into a block. Really late into the day and maybe into the evening knowing it's
It's
you.
been a long day already, Judge.
What?
It's been a long day already.
You don't even know the half of it. All right. Court does call the case of the people versus Devon Gibson. 2 cases.
Alexander on behalf of the people.
Yes, Your Honor, please present before Brandon Bird on behalf of Devon Gibson. Mr. Gibson, can you please state your full name for the record?
David Gibson.
Your Honor, may we approach?
You may. All right, record should reflect we had a bench conference in this case, and my understanding, well, there are numerous calls that council has not had an opportunity to hear yet. There's also going to be a motion to proceed by forfeiture, which the prosecutor is going to file, but without hearing the calls, it becomes a bit difficult to try to respond to some of that. So what we've come up with is I will adjourn with the defendant being in custody. I'll adjourn this just 1 week out to the 13th, to May 13th at 9 a.m. That'll be before me. I also told counsel that as long as I receive the response to the motion by the 12th, I'll be prepared to go on the 13th regarding that. So I'll adjourn it out to that date. Bond will continue, I believe, as for the vote.
Thank you, Your Honor.
All right, thank you. That's called the case of the people versus LaDonda Skinner.
Alexander on behalf of the people, Your Honor.
For the judge, Portugal Police Assistant Public Defender on behalf of, but not with Mr. Skinner.
Show up today, you don't have a client.
I unfortunately, that is the case. Yes.
Okay. So he already has a failure to comply bench warrant out, so. What is that? Is that a no bound?
Yes, sir.
All right. So what I will do is I can do it 1 or 2 ways. I'll just issue a bench warrant. I'll just leave that bench warrant, leave that outstanding.
Thank you, Judge.
Thank you, Your Honor.
All right, thank you. Case people versus Sadie.
Alexander on behalf of the people, Your Honor.
Your Honor, Michael Vincent on behalf of Sadie Fodderall, who is approaching.
She's right there.
Vincent, just go to the side you normally are supposed to be on.
I'm dancing, Your Honor.
Not very well, but go ahead.
I tried though.
Yes.
I can make another comment, but I'm not going to.
No, I'm glad. All right.
Your Honor, may we approach?
Give me one of those days. Sure, come on.
Your Honor, today's the date and time set for preliminary examination. At this time, the people are unable to proceed as to count 1. I would ask that count 2 be remanded to 14B District Court.
I will continue the plea of not guilty as to count 2. I'll set a pretrial in that matter in 14B for June 16th,
Yes.
June 16th, 2025, 10 a.m. That's before Judge Washington.
Yeah, may we address bond?
You may.
My understanding that the gentleman involved in this case would like contact.
And that's correct, Your Honor. He is here and would like to address the court.
Once you.
All right.
Yeah.
You'll have to over that. Sorry, sir. Afternoon. What's your name?
Ryan Busick.
Okay. What do you want to tell me?
I would like to remove the no contact order so we can possibly work on coming back as a family, and I miss seeing my kids every day and all that. Kind of at a loss of words for it.
Pardon?
Kind of at a loss of words for this. Just the fact that I would like the no contact order removed, if that's possible.
And there are 2 children involved?
Yes.
Okay. All right. Thank you.
Thank you.
Benson, do you, ma'am, you can. You don't have an objection to that?
No, Your Honor.
Is I will delete the no contact provision. I just want to double check and make sure. Well, I don't. Well, let me ask this. Are they requesting contact other than just parenting issues?
He is here.
Because that's already, when I look at this, that's already in place. So it's only consensual contact for parenting issues.
I think the request is more than that from my client's understanding. She's living with his mother right now. Her mother.
Pardon?
My client's living with her mother on Hemp Hill. The family home is on Bagley. They got 2 little kids. I believe the father, who you just saw, is working and trying to handle the 2 little kids. I think there's an effort by this couple to try and put things together. That's how I read what.
Is that right, ma'am?
Yes.
You know, that's normal. Just tell you.
So the way that I'll do this is I will delete the, I guess, really the consensual contact provision. Provision for, yeah, I'll delete the consensual contact for parenting. And then I will add no non-consensual contact for any reason. So what that means, ma'am, if for whatever reason he doesn't wish you around him, then you need to leave the area. You understand that?
Yes, I do.
All right. In all other respects, bond will continue.
Thank you, Your Honor.
Thank you.
Calls the case, Beaver versus Dominique White.
Ally's on behalf of the people, Your Honor.
Oh, really?
Was you doing something?
I did.
Did you? Oh, okay. No, my bad. Oh, I see it.
That is on behalf of Mr. White. Can you state your name for the record?
Dominic White, Your Honor.
All right, thank you. What are we doing?
Your Honor, today comes up with preliminary examination. At this time, I would be asking the court to add a count 2 of domestic violence second offense with the PAC code 750.813. And people would be unable to proceed as count 1, would ask that count 2 be remanded to district court.
Okay, so part of that's going to be a bit of a problem in doing that this way. We did it before. I did it before. And theoretically, I would need a new complaint with that charge on it. I don't mind sending the defendant. Can you get that done quickly?
Yes.
Okay, so what I'll do is let me pass the matter, get that done so that I have that complaint before me. Is there going to be any objection to the adding of that charge?
No, Your Honor.
All right, okay, so then we can do that so that he can properly know what the charges are.
Okay.
Because, all right,
So, okay.
the next one, is this one also in custody?
Is it custody, Your Honor?
But not on here.
Correct, back here.
Okay, are they bringing him right back up?
No.
No? Okay. Then I'll do this one. Court does call the case People versus Antonio Cornelius.
Yes, Your Honor. I think this is Mr. Ward's case.
Well, Marie Tanhouse, the prosecuting attorney, standing in for Mr. Ward, and he's on his way.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Cornelius, who stands to my right, please state your name for the record, sir.
Antonio Cornelius.
Zachary Ward on behalf of the people.
All right, I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Your Honor, the defendant will be pleading guilty to count 3 as charged, as well as adding count 4.
Well, the form doesn't, that's what I'm trying to figure out,
Okay.
because it doesn't say that. But it says the count 4, but not count 3.
Where would I add that?
Anywhere would have been better than nowhere.
You could handwrite that. The defendant would also be pleading.
Well, yes, I'll be more than happy
Yes.
to do your job.
I'm rusty, Your Honor. I'm not here.
All right, it's the court's understanding that the plea agreement form that the defendant is going to be pleading to guilty to the stated count 3 of malicious destruction of personal property, 200 to 1,000, the 1-year offense, and also an added count 4 of attempted resisting and obstructing the 1-year offense. Upon his successful plea to those charges, counts 1 and 2 would be dismissed. And there is a consent by the prosecutor to HIDA. That is the court's full understanding of it.
Yes, Your Honor. Yes, Your Honor, that is the agreement that I have discussed with my client. He would like to accept that offer today.
May I have him sworn?
Raise your right hand. Solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God. State your name.
Antonio Cornelius.
Stated his name. Sorry. All right. Sir, it is this court's understanding that you're going to be pleading guilty to 2 misdemeanor charges. Is that your understanding?
No.
Is that your understanding, Mr. Cornelius?
Yes.
Sir, do you want to enter these pleas?
Yes.
Are you going to answer my questions then?
Yes.
You understand that you'll be pleading guilty to 2 misdemeanor charges?
Yes. Your Honor.
Counsel approach, please.